All right, I'm going to go ahead and call to order the meeting of the Board of Adjustment for June 28th, 2018, and I'm going to start with roll call. Board Member Bagley?
Present.
Board Member Martin?
Present.
Board Member McClintock?
Here.
Board Member Primo?
Here.
Board Member Johnson?
Here.
Board Member Madrid?
Here.
And our Vice Chair, Jenna, is not here. Next on the agenda was our introduction of new board members and the election of officers, and I'm going to go ahead and do that part as well. So our election of chair and vice chair for the 2018-2019 Board of Adjustment term. I would like to first introduce one of our new planners for Board of Adjustment, and that's Rob Haig. We also have 3 new members of the board. Tom Martin joins us as a full regular member of the board. Mike Madrid will be our alternate 1. And Kent Bagley is our alternate 2. Welcome to the board. Jonathan Spencer was our chair for many years, and he is term limited, so he is no longer our chair. All 7 of our board members will be able to vote in tonight's officer election. In a moment, I will call for nominations for chair, not a motion, but nominations. This action does not require a second. After all nominations have been made, I will offer the floor to each nominee just to provide a brief statement. After all statements have been made, I will ask for a motion to appoint so-and-so for chair for a term of 1 year. A second is required at that time, and I will do a roll call vote. So you will not use the voting board. I'll go down the line and ask each person. This process will end when a nominee receives a majority vote of the Board of Adjustment. The same process will then be used to elect the vice chair. Okay, so I'm now going to call for or entertain nominations for chair. Any nominations for chair?
I'll nominate Don Jenna.
Okay. Any other nominations for chair?
I'll nominate myself, if I can do that.
Okay.
Interesting. I mean, if Don was here, I would defer to him.
We have 2 nominations.
Okay. So right now, I guess each person is able to make a brief statement. Mr. Jenna is not here to do so, but Mr. Martin, would you like to make a brief statement?
I looked at this election process and I just really didn't feel competent to vote. I don't know anybody here, really, and just rather than an affirmation, I was kind of hoping there'd be a time for at least the nominees to say a little bit about themselves, what direction they wanted Littleton to head into, rather than just a simple affirmation. I kind of presumed someone with experience would lead it, and apparently Don has the most experience, but he's not here tonight. So I just hope we can get a chance to know who we're voting for.
This statement would be that time to say something like that. Okay?
Can I ask a question, please?
Yes, of course.
Since one of the nominees is not here, can you describe for us his background, how long he's been on the Board of Adjustment, what other experience he has? And I would ask the same thing of you, Tom.
Okay.
Because I agree with Tom. I mean, I have no idea about anybody that's here.
Mm-hmm.
I've met Tom, and that's really the extent of it.
Certainly. Tom, if you want to answer that question, I can look up real quick how long Mr. Jenna's been on the board.
What, like about a 2-minute thing of who I am and what direction I'd like Littleton to go? I've been a contractor since 1969, was a licensed contractor, and then I've been in the home inspection business since 1985. During that time, I served on various boards of the administration of professional societies, the American Society of Home Inspectors, the American Association of Radon Scientists and Technologists, been president and secretary of the international group on those various boards. I also spent about 8 years being a junior warden of a historic church on 6th Avenue in Gilpin down in Denver, and was on the vestry there, which is a similar thing to the board here. My feeling about this position and where I'd like to take Littleton is Littleton's already been number 2 in small cities in the country. I think it's a fantastic place and everybody's done a fantastic job. And I'd like to do what I can to make it better. I realize that all zoning ordinances don't fit all situations. And empathy is not my strong suit, but we need to be empathetic to the homeowners, but not at the expense of the neighbors and the rest of Littleton. I'd like to think all the variances that we approve are ones that would enhance Littleton and make Littleton a better place to live in.
And I do have here on the clerk's roster that Mr. Jenna was first appointed in April of 2015, and last year was his first term as vice chair.
First term as vice chair? Tell me something else about him.
Trying to recall, not to speak for him, but I do know, I believe that his interest in being on the board was similar as a, citizen of Littleton and wanting to give back to the community. Those are just some of the general statements that I feel that we've had in conversations with him in the past.
Could you provide me with anything about his background?
I'm sorry, I don't recall that, no.
Okay.
Don't have that.
Thank you.
So at this time, I'd like to ask for so we have 2 nominees, Mr. Jenna and Mr. Martin. And at this time, I ask for let's see. Those are the 2 nominees. I now need a motion to appoint one of these for
Do
chair.
you need to close the nominations, or have you already done that?
I move that we close the nomination.
No, we have not
process.
closed the nominations. Does anyone else want to?
I move that we close the nomination for president.
Sorry, I'll jump in. I'll self-nominate since we haven't closed yet.
Yeah, we have not closed the nominations.
All right.
Would you also like to make a brief statement?
Sure. So my name's Scott Primo. I've been on the Board of Adjustment for about 2 years. I may be one of the least technically experienced board members in terms of building codes, building knowledge. However, I do feel I'm a quick learner and certainly very capable of digesting some of the regulations and city code that we have to deal with. And also, I have had some experience and seen a few fairly interesting issues come up to the board, some involving the Carmelite Monastery. We had a fairly interesting case where we actually had to, didn't have to, but we voted to overturn a city decision, which we did not take lightly. And I would say, as much as I'm sure we're all interested in helping Littleton become a better place and continuing to have it thrive as a community, I don't see this role as really dictating what Littleton's going to become. When we look at a case, I don't feel that it's my job to say that makes Littleton a better place or not. It's more matter of fact, looking at staff recommendation, looking at the city code and the variances, and if the request meets those exceptions or not, and then discuss from there. So, and I would be honored to help serve the board in all the future matters for the term of the chair. Thank you.
Can I ask a question?
Yes.
What's your background?
My background for the last about 12 years has been project management, working in a few different fields, healthcare, the legal industry, and state government, mostly on IT projects, and prior to that worked in kind of policy and support in state government.
Thank you.
Any other nominations for chair?
I move we close the nominations.
I second the motion.
All right. That's a motion, so we'll have to vote on that. Let me go down the line. Let's vote on closing the nominations.
Aye.
Bagley, Martin, McClintock,
Aye.
Primo,
Aye.
Johnson, Madrid.
Aye.
Okay, that's unanimous, and that motion carries. Okay, so now I'm looking for a motion for chair.
I make a motion to appoint Tom Martin.
Okay. Do I have a second for that?
Is it appropriate to have a second for me? Okay, I second the motion.
Okay. So I have yeah, anyone can second. Okay, so this vote will be for Tom Martin for chair. I'm going to go down the line and get everyone's vote on this one. Member Bagley?
Aye.
Martin?
Aye.
McClintock?
Nay.
Okay. Primo?
Nay.
Johnson?
Nay.
Madrid?
Nay.
Okay. I'm going to need some help later. Okay. All right, that motion fails. I'll need to entertain another motion for chair.
I'll make a motion to appoint Scott Primo to chairman.
Okay, it's a motion for Primo for chair. Do I have a second?
Second.
Okay, there's a second from McClintock. We'll go down and vote on this one. Bagley?
No.
Martin?
No.
McClintock?
Aye.
Primo?
Aye.
Johnson?
Aye.
Madrid?
Aye.
Okay, that motion carries. Member Primo, you will now be the chair. And now we're going to do the same process over again for vice chair. So I am now going to entertain nominations for vice chair. Anyone want to nominate somebody for vice chair?
I'll nominate Tom Martin.
Okay.
Second.
Bagley nominated Martin for vice chair. And McClintock seconded. All right, any other nominations for vice chair? Any other nominations? All right. Would you like to make a new statement, or does your previous statement stand?
Yeah, I move the nominations for vice chair be closed, or do you want another outline of my history and motivations? I think it's redundant.
I think we're good. And I'll actually just go ahead and say that we'll close the nominations, so we don't have to have.
Second.
I'm just going to
Close.
close the nominations. Okay, so now I'm looking for a motion on the table for vice chair.
I move to appoint Tom Martin to vice chair.
Okay, second, please.
Second.
Okay, so that's a second from Bagley. Okay, I'm going to go down the line.
Aye.
Bagley, Martin,
Aye.
McClintock,
Aye.
Primo,
Aye.
Johnson,
Aye.
Madrid.
Aye.
All right, and that's unanimous for Martin for vice chair. Okay, so if we want to do a quick little musical chairs here and rearrange our seating, then we can continue with the meeting.
There we go. Switch.
Aye. Are we scooting over?
Chairs here.
We'll see. Literally.
I think I'm voting now, so. Are we scooting over? No. Okay.
Through the red text.
Works for me.
Wasn't far to go.
Like the elbow room.
And the red text will help you get through it. Since that is we're doing a regular roll call. I'll just continue. Is that good? And since Dawn is out, we actually, don't need to move. You will actually be a voting member tonight
Great.
as alternate one.
But we can stay here.
Yeah, go ahead.
Okay, great, thanks.
Show up and move up.
Like this.
Regular. Okay, thanks everyone for your patience. I'm turning the meeting over to Chair Primo.
Thank you. So our next business is to approve the minutes from the March 15th, 2018 regular meeting. I'm looking for a motion to approve the minutes.
I move to approve, based on the recording secretary's certification, the March 15th, 2018 action minutes for the March 15, 2018 regular meeting of the Littleton Board of Adjustment.
I'll second.
Any
Point of order.
discussion?
Point of order. The two alternates can't vote, right?
You won't be able to vote tonight, sir, but because we have somebody absent, alternate one is going to be a voting
Okay.
member tonight.
Good, thank you.
Yeah, but you are welcome to take part in any
Oh, I
discussion.
understand that. Okay.
Thank you. All right, and I'll go ahead and go down the line for voting. McClintock,
Aye.
Martin,
Aye.
Primo,
Aye.
Johnson,
Aye.
Madrid.
Aye.
Okay, motion carries.
Okay. Our next order of business, public comment. Public comment is an opportunity for anyone to express opinions or ask questions on items that are not part of the public hearings. An immediate response should not be expected. Anyone who would like to speak during the public comment, please sign in on the sign-in sheet located at the table. We expect comments to be civil. Disrespectful behavior will not be tolerated. There is a 3-minute time limit per speaker. The recording secretary will hold up a yellow card to indicate that 30 seconds remain, and will hold up a red card to indicate that time is up. When your name is called, please proceed to the podium, speak directly into the microphone, and provide your name and address. And are these people signed up for general public comment or comments on the petition in front of us?
General public comment.
Okay, great. We do have, looks like a few people signed up. I believe it's Orville Kern first. Would you like to share any comments?
Sir, I would like to follow Ryan here.
They're intended for the first hearing.
Not general.
Yep,
Okay.
okay. Thank you. In that case, seeing no public comments, that brings us to our public hearing. And our public hearing is for BOA Resolution 03-2018, case number VAR 18-002, variance from the maximum height for a fence in a residential zone district at 6698 South Arapahoe Drive. And thank you.
All right, good evening. Is the screen in front of you working properly?
It is now.
All right. Well, thanks for taking the time to meet with us today. My name is Rob Haig. I'll be representing the Community Development Department. As you stated, we're going to take a look at VAR 18-0002 for a variance from the maximum fence height allowed in the residential R2 zone district. The subject property is located at 6698 South Arapahoe Drive. This site vicinity map shows the general location of the subject property. In this image, it's highlighted in yellow. The lot is just under 0.3 acres. It's zoned R2, which is a single-family residential zone. It is in the Maple Ridge subdivision, Lot 29, Block 2, properly platted. The variance request is to allow for a fence that is 8 feet high in the areas shown on this image before you. So the areas in purple would be the sections that are 8 feet. The remainder of the fence would be 6 feet, would be within the standard allowed regulation per the code. So some site photos. This is the site along the southwestern property line. You can see here bracketed is the section of fence we're approximately looking at. So here, kind of the main feature of the property and the adjacent properties is just beyond the subject property line. The adjacent property steps up in grade 3 feet at the maximum. And again, this is immediately outside of the subject property. The fence is proposed right along the purple line. It's actually on the bottom at the toe of the retaining wall. This is another image of the southwestern property line. This purple image is something that I superimpose. It's approximate. It might be off a couple inches in either direction based on where the fence would actually be constructed. However, this is solely just to demonstrate the immediate grade change once you leave the subject property. So a similar condition along the southeastern property line, not as extreme, but you can see just below the existing fence, which is deteriorating. There's a retaining wall of sorts, kind of composed of stacked bricks, some railroad ties, sometimes just dirt grade. And this is in some places 2 feet in distance between the grade on the subject property and to the adjacent property to the southeast. This is another image kind of looking in the opposite direction at that same fence. Again, you can see in places it's railroad ties, stacked bricks, and some places it's falling through. The fence would be located and the height of 8 feet would be measured from the subject property on the lower side of this retaining wall and existing fence. So the criteria review staff did review this variance application in accordance with Title 10, Chapter 11, 1B. The variance will not authorize an operation of a use other than those that are specifically listed as primary permitted uses in the zone district in which the affected property is located. Fences are permitted in the R2 zone district. The existing principal use on the subject property, which is a single-family residence, will remain. Because this proposal does not include any additional uses, staff finds that this criterion can be met. Criterion 2 states that the variance will not alter the essential character of the neighborhood or the zone district in which the property is located or substantially or permanently impair the allowed use or development of adjacent properties. The privacy fences 6 feet in height are common in the neighborhood. Due to the location and the specific conditions of the subject property, the full height would not be immediately apparent to the adjacent property owners or the adjacent properties that do sit at a higher elevation. In addition, since the fence will be located on the subject property, staff finds that this will not impair any of the uses on the neighboring properties and therefore finds that this criterion can be met. So, as I previously stated, the retaining wall on the southwestern property at its highest is 3 feet tall, and the variance is requesting a 2-foot increase in height. Additionally, on the southeastern property line, the grade change varies from 1 to 2 feet, and this increase in height would allow 2 feet in additional fence height. And the variance is the minimum that would afford relief and is lower actually than the height of the retaining wall on the southwestern property line. Staff finds that this criterion can be met. Criterion 4 states that the variance will not adversely affect public health, safety, and welfare. The fence will be located on the subject property and will not materially impact any of the neighboring properties or any of the public who might be passing on the adjacent rights of way. Because the neighboring properties are at a higher elevation, again, they will not directly perceive the full height of the fence, and will not be negatively or adversely impacted by the additional height of the fence. So the hardship, if any, under which the variance is sought was not created by the owner, the occupant, or the agent of the owner of the property in question, nor was it suffered as a result of violation of any provision of this code. So the property owner purchased the property with this condition existing. Additionally, the retaining wall that creates this exceptional and extraordinary condition is not located on the subject property and is therefore out of the control of the property owner. The retaining wall and grade change also existed prior to the ownership of the current property owner. Because of this, staff finds that this criterion can be met. Therefore, based on this analysis and the slides that we've just gone through, staff recommends approval of BOA Resolution 2018-03. Staff is open for any questions, and the applicant also has a prepared presentation. Yes, sir.
Thank you.
Basically, you're creating a double fence, one against the retaining wall and another against the neighbor's dilapidated fence. Is there any provision in the design to have the bottom of the fence elevated 4 to 6 inches to allow a weed whacker to get in there and trim the weeds that will be growing between the fence and the retaining wall or the double fence?
That is not, and that's a great question. So my understanding is that the fence at the southeastern property line will be removed, and this will be, in effect, the replacement fence on the subject property.
Okay.
So in that sense, that one should be easier. I did talk about the maintenance issue that might arise with the fence against the retaining wall. They informed me that they have talked with their neighbor on how that maintenance would occur, whether either through a weed barrier at the bottom edge of the fence or allowing adequate space for someone to move in and maintain that area. However, because this variance is looking at the height, the additional height of the fence rather than the location, even a 6-foot fence in this location would present those same problems. And staff finds that these are things that can be addressed through the applicant and their agreements with their neighbors, which it sounds like they have considered.
Thank you.
Yes, sir.
Perhaps this is a question for the applicant, but I see there's 2 letters of support for this fence. I just wonder about the proximity of these addresses actually where they are in relation to the subject property.
I'll allow the applicant to address that or correct me, but I believe it's the directly adjacent properties at the locations where the fence would be above the 6 foot that is normally allowed.
Okay.
I have about 5 questions I'd like to ask.
Yes, sir.
Was there a documented and completed survey with this application?
There was not. Not that staff received. The applicant may have produced one.
Okay, so we don't know if the fence is on the property line or not, the new fence,
Not based on a survey.
because there was no survey provided to the staff.
Correct.
Okay. Is the existing fence on the subject property as defined by a survey? Since you don't have a survey and the property owner may not have a survey, we don't know where the existing fence is, do we?
That's correct. Our understanding and the review was based on that fence being at the property line. But again, you're correct. Staff is not aware of a survey that does confirm that.
Part of the reason that I asked that question is because based upon the documents that you provided to us to review the pictures that you showed, it shows where the property line might be, but we don't know whether it is. So that's a concern. And do you know whether I'm assuming you don't know whether the new fence will be erected on the property line along both the south and the east property lines, because you don't have a survey, so you don't really know.
So to construct a fence on the subject property, it would have to be on the subject property to get the building permits and move forward.
That may be a question for the applicant, but
I agree. The variance would be specific to the fence being measured from the lower end, so we don't have the concern of an 8-foot fence being erected on top of either of these retaining walls because of the specificity in the variance.
yeah, and I know that this is really a fairly simple request and an improvement request, but I think that some of these questions are germane not just to this application, but in the future, I would suggest that you require a survey if there's going to be a fence so that we understand exactly where the fence is going to go. And the toe of the retaining wall, we don't know whether that's on the property line. We have no idea because we, again, don't have a survey. That's the concern that I have. And I think that you mentioned an issue which was a concern to me when you put a fence next to the retaining wall, and that's how does weeds, trash, all that get, because it's about 3.5 to 4 feet drop from the top of the retaining wall down to the fence. So you're going to be like this. It's going to be very hard to deal with that. So I don't have a vote on this issue, but those are questions that I'm going to want some kind of response from the property owner, and I think that there absolutely needs to be a survey. Thank you.
Thank you. Yeah, noted. And so again, I just want to reiterate and I'll get to you in just one second, I'm sorry, that the lines that I drew on there were just based on staff's understanding that the property line is at the toe. They were not the direct representation. Of course, they're not survey accurate. And I do understand that concern.
Sure.
Another point I want to bring up again is that the fence variance request that we're looking at is in regards to the height. The location of the fence, even if it were a 6-foot fence in that location, would still bring up those problems, which are valid. And that's all I would have to comment there. So, Madrid, if you have any questions.
Yes. What are the documentation requirements to obtain a fence permit?
That's a good question. I'm not exactly sure. I don't know if there's someone that could answer that from the building permits, from the permitting process. But the fence would require a fence permit. That's really the length that I could answer.
And just so you guys know that when any applicant comes to the city to pull a fence permit, the requirement is that it must be on the property. We generally do not necessarily require an ILC or something to verify that, but whatever information they can provide, and then if there's a question, then we can, we can go from there. So, but generally, we work with what people provide us and, make a call around the information that they have. But not always do they have a survey, but we usually can try to find something that's pretty close. But we do aim to, the requirement is that you have to install a fence on your property. Certainly we have in other instances when there's a dispute between neighbors, then, that would require someone coming up with a survey to indicate if it's on the property or not.
My response to that is I understand and I agree with that, but by putting up a new fence, taking down a fence, having a retaining wall, and the location of the fence, there could be problems in the future with code violations, and I'm just trying to make sure that in the future we don't run into that issue. So that's the reason for my question. Thank you for your presentation.
I think the variance before us is the height issue, and I haven't seen anybody articulate any objections to the height. There's valid questions, but I think they really need to be addressed by the permit department as to whether there's sufficient monuments to need a survey, or is it obvious and defined? We'd like to think that the neighbors would work something out, either paving that area with a weed barrier, allow a gap to clean out trash and weeds, but those aren't really, I think, the questions before us, the implications of the double fence, rather the height. And I would move that we close the discussion, and I move that this variance be approved.
Actually, we still have the applicant has an opportunity to present before we make a motion.
Okay.
Thank you.
Yes, sir.
I still had more questions. That was just the first one. If a fence were to be located on top of a retaining wall, is the height of the retaining wall taken into account for the total height of the fence?
Yes, in my discussions with the building permit department, if the fence is on top of the retaining wall, it would be measured from both sides, and the taller side would be the resulting height that we would consider.
So if the property line ended up being on top of the retaining wall, they'd be able to build a 5-foot fence on top of their 3-foot retaining wall then?
No, I think the variance request that we're looking at here is specific to a fence being constructed on the lower end of at the toe. That's a good question.
So a condition of approval would be that it has to be built in front of that retaining wall?
I think that would be a valid condition.
I noticed on the southeast portion of the property, didn't have that same retaining wall issue. Could you briefly go over what exists there and how tall it is and what we're looking at there?
So it's hard exactly to tell, especially from these photos. The applicant might be able to give a more accurate, exact measurement as far as how big some of these differences are. It's definitely not the 3 feet, or it's not as extreme as it is on the southwestern property boundary. But you can see in a couple places where there are stacked railroad ties. So at least a foot and 2 feet in a couple places. Some places it's less. And it's difficult to kind of have the varying fence height based on exactly where and the higher and lower portions are of this retaining wall. I think staff's kind of basis for our consideration of the approval of this variance and our recommendation is that that there is this immediate grade change, and then beyond this, the property continues to slope. So even though it might not be extreme, there is a similar immediate or somewhat immediate change in grade just beyond the property boundary.
Yeah, and I think we could see that with that structure in the back of that picture. You could see how much higher up it is than where you're standing taking the picture. So thank you, that's all I have.
Thank you.
Any other questions for staff? Thank you.
Thank you.
Would the applicant like to make a presentation and take questions?
Get it teed up.
Hi there, board. Thank you for giving me an opportunity. My name is Ryan Herman. I live at 6698 South Arapahoe Drive. I have to apologize. I am an animal trainer. I am not in permits, building, or city government, so my PowerPoint doesn't look as pretty. But just to introduce you, as you say, I'm a citizen as well as my family of Littleton, born and raised in Littleton, and I think it's about people, so I wanted just to introduce my family. Again, my name is Ryan, my wife is Heidi, my son is Maddox, and my daughter is Meadow, and they're getting an opportunity to see civil government at its finest. Thank you. We are considering case VR 18002. The purpose of us being here and you guys sharing your time with us is we would appreciate the board as well as the city's approval for our 8-foot fence to improve our family's safety and privacy. Again, his map was much better. I like smiley faces, so that's a Google Map screenshot. This is our house right outside there, and our other member of our family who couldn't be here today is Butters, our puppy. So briefly, just our fence story. Last year, at the beginning of June, we moved into our first ever home as a family, first homeowners, and as hopefully some of you on the board would attest, when you first get your very first home, you fall in love with it, but also have to make sacrifices in what you want in a house because of the affordability. But we wanted to be homeowners, and we decided this would be a perfect place to raise our kids and send them to school. We love our backyard. We spend a majority of the time, especially now, not this current week, but a lot of the time outdoor. You might have seen the house. We have a swing. We have a dog. We have lots of yard games. We value our outdoor time, and it was one of the incentives and the main reason we chose our house, as well as chose the city of Littleton to raise our kids. We knew that we were taking the low ground. I don't know much about the military, but when I see the movies, taking the low ground and not having the height advantage is a factor, but we decided that we loved the house the most and we were going to take that. The next step, come October, is we lost one of our cats, Creeper, our hairless cat. Really devastating blow for our daughter and our son, so what's the best thing to do is let's get a dog. So that's our dog, Butters, both in her prime as well as spending some time with my daughter in a mermaid outfit. back to it. As we get to know the community and others, we like to welcome friends and family and host at our house and take pride in that. And with that, we have friends that come over and enjoy our backyard. These are a couple Mongolians that we hosted this summer, and they thoroughly enjoyed our backyard and our games. And as well as humans, we like our animal friends as well. So this is her friend Aoife. As you'll see in future pictures, we have a fence that is dilapidated that we share with our neighbor that is a safety issue, and that sped up the process of investing into a fence into our home. Realizing that I'm a guy, I can build it, was quickly cooled down by my wife saying, let's call a professional. Again, his drawing was much better, but this is the one that, so you guys know, so Kent knows. If you have questions, I'm not too well versed in the permit process, but I can tell you what we had to submit. This was one of the things that we needed to submit, which is a blueprint that our fence contractor drew for us, and then I added the compass as well as the cardinal, the northern cardinal, and where the 6-foot fence is. Our goal and our vision is to install a white vinyl fence. We wanted to share with you that to show that this is in improvement, and we feel that not only will it improve our home and our life and our property value, but because of the fence and the investment into a nice fence, we think it'll improve the value of our neighbors. This is a couple of pictures of the current fence. Neither the neighbor nor us constructed the fence or have any documents on who owns the fence or the retaining wall. So we together, he couldn't be here, but we have signed documents by both of the adjacent homeowners of agreeance to this fence as well as the 8-foot variance. And we have come together to agree on building a new retaining wall as well as the fence and share those costs. Again, here's the lack of privacy pictures. I didn't know he was going to do this presentation, so I just wanted to share you that. And then the height, where the tape measure is on my chest is a 6-foot fence. So again, the lack of privacy if our neighbors are outside there. This is a better picture that I believe shows you the slope and elevation of our adjacent neighbor that shares the smaller retaining wall. That's him in the very middle, just walking. His deck looks right into us, so that is part of the justification, not just the retaining wall, but the slope and elevation of his back patio is so much higher than ours. Also, we are hoping to do a fence, as you could see by the map, the street Arapahoe and the headlights come right into our backyard, and it is becoming a busier and busier street as a cut through to Stern and then to Broadway from Ridge. And just some concluding thoughts. We believe that we can improve our family's life by installing an 8-foot fence on the southern and eastern portions of our backyard, improving the value of our home and the homes of our neighbors. Like I said, we have two signed documents of their approval of both those homeowners. We see this as an immediate need because the existing fence needs to be replaced for safety reasons. Our property is much lower in elevation than our neighbors and reducing our privacy and safety. And lastly, we are committed to be citizens of the city of Littleton and hope to have a great life here and send our kids to Heritage. Thank you very much for your time tonight.
Thank you. Are there questions for the applicant?
I have one question. You mentioned that you do dog training, I believe.
I'm an animal trainer. I've worked formerly at the Denver Zoo. I currently train otters and binturongs at the aquarium.
So you won't be training timber wolves in this backyard that couldn't be contained by a 6-foot fence?
No, just that dog Butters. That is a handful, but I will not be bringing in lions. I'll keep the tigers at the aquarium. I get my just from them there.
But just no animal that wouldn't typically be contained by a 6-foot fence?
No, and I would meet the permits and the ordinances of wild animals. I just share that to show you how unprofessional my PowerPoint was. I'm not planning on bringing any crazy animals over.
I did have a question as well about, you mentioned a new retaining wall. Is a new retaining wall part of this project?
It was under the 2-foot permit need. So after talking to Pam in the city permits, as well as Ernie Rose, they told me that I did not have to submit any permit for the retaining wall, so this was not part of the city ordinance. We would do that in accordance, but we would not need a permit for that. But yes, it is part of the plan.
There to be a 2-foot retaining wall and then an 8-foot fence on top of that?
Incorrect. The retaining wall will be on our neighbors, paid by our neighbors. All of our fence contractors told us to not build a fence on a retaining wall for the stability and the longevity of a fence. So we are honoring there, and even though we might get an extra foot or two, as you can see us going through this process, we want to do it the right way and want to make sure that our property value stays still, and I do not have to come to you in 5 years for another property variance.
Still a little confused where the retaining wall is going to go.
The retaining wall will go where it is currently, and then the fence will be on our side of the property adjacent to the retaining wall.
So it's going to retain the people to your southeast, the neighbors to the southeast?
Correct.
Okay.
Any further questions for the applicant?
Yes. I think you're doing a great job. 8 feet doesn't bother me in this particular condition. Have you had a survey done, a documented survey?
We have not had a documented survey. This is my first home and first big project. All the fence contractors, which we have spoken to 5, as well as our neighbor, as well as our real estate agent, told us we did, and the permit told us we did not need to do a survey. So that is why it was not done.
Yeah. You just need to make sure that the retaining wall that's about 3 feet high, because it slants, you can see that at the top, it's probably 1.5 feet. I don't know where the toe of the slope is. I think it's important for you and the satisfactory completion of this project to make sure that you're putting this on your property and you're defined and you know that that's where it is. I know that's how I would feel, but
Okay.
That's up to you.
Well, thank you, Kenton. I think your questions have made it very clear that I should get that done.
I think it might be appropriate.
Appreciate that, sir.
Can you discuss a little bit about the safety aspect? That I know a lot of times there's mention here about safety and safety and safety. Can you just talk about that a little bit? Safety in regards to what?
Sure. I know you probably are regarding it to both, so I'll start with the existing fence. There are many planks that are coming down. Our neighbor, I believe, has lived there since 1998, and it was a dilapidated fence then, so no one's had addressed it. So are you okay with that piece?
Oh, I agree.
Okay.
Yeah.
So the other side of it, as I was trying to show, is just as I have my kids out there, I would like to leave them, if needed, to go and cook and to keep an eye on them, and our neighbors to the side that we have a great relationship with. And I'm not concerned about that necessarily, but anyone from the Arapahoe, or a lot of people come walking by there, it's right by the middle school as well. I just want to make sure that they can't walk on that retaining wall and jump the fence because it's only 2 feet higher than, it would go to their thigh or their knee. So the advantage of a fence, be it 3 feet, 6 foot, 8 feet, 20 feet, is the discouragement of anyone trying to jump the property and the ease of that jumping.
Okay, thank you.
So with the fence, is it going to be enclosed all the way around?
Correct.
Okay.
And that was part of the dog. It's not just a safety thing, but we like to have our dog be able to run when it's not running into our neighbor's yard, like Orville might share here soon.
And this may actually be a question more for staff, but with the variance, I see in the plans, it talks about only 2 sides of the fence, I think, being 8 feet tall. Is this variance applicable to the entire fence or only those sides specified?
So the variance request is specific to the application that we received, which only is requesting the 8-foot sections on where it was shown in my and Ryan's diagram. My purple and green outline is just a direct overlay of what Ryan's drawing was.
Great. Thank you.
Another question too about these, your neighbors at 6719 South Delaware, are those the people behind you, southeast, or is that southeast? Your backyard?
Yes, the one with the retaining wall that's in the fence that's dilapidated? Yes.
And the other neighbors at 6728 are the ones with the 3-foot?
Correct.
Okay.
And they couldn't be here tonight, but they both supported it, and I have documents of that.
That's.
Oh, you have that,
support,
great,
yes.
thank you.
Any further questions?
I'm good.
Seeing, thank you.
Thank you.
Seeing no further questions, we will now open it to public comment. So for those who have signed up to comment, a reminder that we do have a 3-minute limit per speaker, and please state your name and address when you come down to speak. And we have Orville Kern.
Hello, good evening.
Good evening.
I am Orville Kern. We live next, we have the honor of living next to the Hermans on the north side, more north. I would say, to sum up my comments, that we support a 6-foot fence on our property, between our property and their property. That's all there is to it. We agreed on this back in early spring. Verbal agreement. We didn't write anything down, but we could. In preparation for this meeting, I found that I have messed up, and I wish to confess that to this audience. We need to talk. The fellow who does our grass has to go over the neighbor's property in order to get into our backyard. This fence will cut that out. My error is in thinking about an earlier agreement with former owners before the Hermans, and I had access to my property from that. The fence indicates that we will have to do some sort of ramping in order that he get his machine from one place to the other. In other words, another access to our backyard. I am willing to do that. In fact, I have to do that. That's all I have to say. I support the request.
Thank you. And were there any other public comments? Okay. Seeing no further public comments, I close the public hearing, and now we'll look for a motion from the board.
I move to approve the variance of the fence height to 8 foot as specified in the packet that we were given. I don't have the number immediately before me.
Is there a second?
I'll second.
And is there any discussion amongst the board?
I'll offer some comments. In looking at the application and its relation to the hardships that have to be met in order to be granted a variance, I believe this fence won't have any impact off-site that would be visible from the street or from the traveling public. And driving by the site myself, I wasn't able to see anything toward the back in terms of how high the fence is going to be or how tall the fence is going to be. I don't really think that the level of impact that it will have I think it will be beneficial to the property owners rather than an impact to the neighborhood. It does meet the criteria of hardship. I'll agree with staff, and that's probably how I'm going to be voting.
Any other discussion?
I tend to agree, Mike. I think it's, beneficial for the neighborhood, beneficial for the applicants, the citizens. I don't think it'll be any problems, particularly given the adjacent neighbor's support. That's an important thing. Given those things, I would certainly support the new fence. I know there's been a lot of discussion, I just want to throw this out there, a lot of discussion about the location of the fence. But again, if it were a 4-foot fence or a 6-foot fence, it would be the same process if it were 8-foot fence or shorter fence. I just happened to pick up the fence permits on the way in tonight, and it is, well, as we heard earlier, it's just simply a drawn to scale. It doesn't talk about surveys or where the fence is. That's, I think to Tom's point, beyond our discussion here. We're here to discuss the height of the fence. So.
Seeing no further discussion, we'll vote.
I'll go down the line. Member McClintock?
Aye.
Member Martin?
Aye.
Chair Primo?
Aye.
Member Johnson?
Aye.
Member Madrid?
Aye.
All right, it's unanimous and the motion carries. Congrats.
Okay, thank you. Our next order of business, are there any reports from any development staff or anyone else? All right, then we will adjourn this meeting of the Board of Adjustment, and the board members will reconvene in the community room for a study session in 5 minutes from now. So, thank you.
Thank you, Board.
to be done in less than an hour. Maybe even quicker than that.
Much less. My
I-
birthday's tomorrow, and I would like to get home.
I will make it quick.
Happy birthday.
Yeah.
Speaking of that, if
So-
I'm happy to go.
Do we need to film? Is this recorded?
Yes.
All right, let's begin.
Your birthday, we should at least have snacks. Would you like a snack?
I'll go over, yeah.
Okay, all right. Would you like to do anything? We try to provide snacks for people.
So let's talk about the Board of Adjustment. You really have three major areas of duties. One is you render interpretations based on the zoning administrator's decision on the zoning code, which is Title 10. When you refer to Title 10, that's Title 10 of the city code. You also do what you just did tonight. You handle zoning ordinance variances. And you also handle variances and appeals to the sign code, which is actually a new duty for you, because for years in the city, the sign code was part of the building code, and variances under the sign code were handled by the Building Board of Appeals. That's highly unusual. I've never seen a city in my career that ever had the sign code as part of the building code. It's always been a zoning function, and now in Milton it's a zoning function. Now, the city council is the ultimate legislative body, and it enacts ordinances, and it can enact sections of the city code that pertain to the Board of Adjustment, and it appoints you. Now, the role of staff, we're there to really be your administrative support. We handle everything from the setting up of your meetings to preparing all the documentation for your meetings, and we basically function as your administrative support. How that generally is done is that the chair will work with Jocelyn on your agenda and work on, if there's an issue with meetings, either Jocelyn or her staff will work with the chair on making sure there's a quorum and making sure the meeting dates work for all of you. Now, the city charter, you hear these terms thrown around, city charter, city code. The city charter is nothing more than the city's version of the Colorado Constitution. It forms the framework for city government. The city code is our version of the Colorado Revised Statutes. Now, we're what we call a home rule city, which means we don't draw our power from the state legislature. We draw our power and authority from the Colorado Constitution. And the Colorado Constitution said cities could become home rule cities and basically have all of the powers of the state under the state constitution. Now, one of the most important things is how do you have really good effective meetings? Now, the city has adopted legislative rules, and the legislative rules basically govern how you do your business. There was a lawyer for the Colorado Municipal League, his name is Bob Whitmer. Bob is the city attorney in Centennial. And so he drafted for all of the cities basically a much less formal version of Robert's rules. So sometimes you will hear that the city has adopted Bob's rules. Well, Bob's rules are the less formal version of Robert's rules. So let's talk about what happens in a meeting. Excuse me. First in your meetings, they have fact-finding. Fact-finding is what happened tonight. It's the information that staff presented to you in the testimony that occurred from the applicant. And sometimes there'll be other interested parties. Now, because you're basically, in many respects, what we call a quasi-judicial board, in the fact-finding process, it's important that you maintain a neutral fact-finding mindset. Why is that really important? The U.S. Supreme Court, thanks to the Colorado Civil Rights Commission, discussed that very issue in a case called Masterpiece Cake Shop out of the city of Lakewood. And they said, listen, Colorado Civil Rights Commission acts as a quasi-judicial body. It indicated a hostility to religion, and because it indicated a hostility to religion in its fact-finding, we're going to overturn their decision. That's the ultimate consequence when a board such as the Board of Adjustment isn't neutral in the fact-finding process. Deliberation is the decision-making stage. That's what you did after you had the motion. In the second, you deliberated. Now, you will be called quasi-judicial board. That's a very fancy legal term. What it means is, in certain capacities, you function just like a judge. You literally function in the same way as a judge wearing a black robe. Happens to be an English judge throughout all of the English-speaking world, with one exception, the United States. English judges still wear white wigs. I was in Ghana, West Africa, former English colony. The Africans, judges, all wear white wigs, heritage from Britain. In America, we don't, but I like the picture because it sort of reflects that judicial role. So when you're wearing that quasi-judicial hat, when do you wear it? On appeals. When you have an appeal of a zoning administrator decision, you're acting as judges. The same rules that apply to judges apply to you. Variances, just what you did tonight. You're acting as judges. Same rules that apply to judges apply to you. Now, the City Council recently adopted some rules of quasi-judicial procedure. In fact, they're being printed, and as soon as the printing is done, you will each get a copy of those. But they really outline how quasi-judicial processes are to be done. So who are the parties? The city, in this case usually it will be staff, is a party, and the applicant is a party. So some things that are important to consider before the meeting. First, what we call ex-party communications. Fancy legal term. What that means is you talked to an interested party outside of the proceeding. Judges can't do that. I can't talk to a judge about a case where I'm appearing as the city's lawyer, except in court. If I do that, it's called an ex-party communication, and it's improper. How do you know that a proceeding's begun? Under our quasi-judicial rules, staff will send you a notice saying there's been an application filed, we are now in a quasi-judicial proceeding, please avoid ex-party communications. And that includes city staff. You can certainly request just general information, but you can't talk with city staff about the merits. For example, in this case, it'd be inappropriate to call up Jocelyn and say, Jocelyn, I really hate this fence variance. I really don't want it. What do I need to do to oppose this fence variance? It'd be improper for her to talk to you, and it'd be improper for you to talk to her. Now, we all live in Littleton. We've seen these sites. You're not required to close your mind to what you know. But if you do a site visit on a case, you do need to disclose that to the board. You would just simply say, I need to disclose that I did go by and visit the site. In another city I worked in, we actually had a quasi-judicial hearing, and I don't know why the board did this. I had board members go out and talk to the applicant on the site. Ex-party communication, improper. Perfectly fine to visit the site, just don't talk to anybody.
Question.
Yes.
Can two of us go to a site?
Two of you can go to the site, but don't talk to each other about it, and don't talk to anybody else. Yes.
So, on this ex parte, I got sort of scared off, but it would be appropriate if I wanted to go there with a camera, to take pictures, to look at if there were any property hatch marks on the sidewalk, or maybe even see if there was a survey pin at the corner line, as long as I didn't talk to anybody about it.
You can go to the site, you can certainly take pictures, but if you take pictures, generally those are going to have to be introduced into the record of the proceeding, because they now become part of the record. If you don't take pictures, that's fine, but again, if you do investigations, like we had a case in another board where they did some investigations on a product that was it was a building code issue. Well, all of that investigation has to be introduced into the record. That all becomes part of the record. Yes?
So I mentioned I went to the site during the hearing. Is there a more proper way to bring that up to the board, or just mentioning it in the deliberations?
Just mention it in the deliberations, just indicate. I did go out to the site, and I did see the site. Because when you're a judge, you can only consider what's in the record. Just like when I appear in front of district court judges or appeals court judges. They can't go outside the record. The record is the staff report, any evidence that is presented by the public hearing or by the applicant, any documents that are admitted, but you're limited to the record. You can't consider matters outside the record.
One other question.
Yes.
Is it appropriate, let's use the variance we just went into, to knock on the person's door, I'm with the Board of Adjustments, you have a variance before it, I would like to look at your backyard, but I can't discuss your variance with you.
That's fine, because you're just simply getting permission to go back and look at the backyard. But the danger in that is people will always want to discuss it. And so you have to basically say, I cannot discuss it with you. Yes.
In that situation, are we trying to avoid the appearance of discussing?
Both the appearance of impropriety as well as you don't want a situation where you get into an ex-party discussion, because that can invalidate your decision and a court can overturn your decision.
So while we're saying you can do it, if you happen not to talk about it, we would probably suggest highly that you don't.
And if you do talk to them, say you just cannot control yourself, then you're going to need to recuse yourself from the proceeding and not participate. Now, with a public hearing, again, you have to be fair and impartial decision makers, and that's where you can make the disclosure that yes, I visited the site. Now, we also have, and this will be in the quasi-judicial rules, so I'm going to actually skip this so we can get on to some other very important things. And in the quasi-judicial rules, it outlines the how proceedings are done. Now, occasionally you function as a legislative body, just like the city council does. Some good examples of that. Let me see if I can go back here. You wear this hat when you act and review a decision of the zoning administrator, not a variance, but where you're just reviewing the decision of the zoning administrator in terms of her interpretation of a piece of legislation. You don't, as a Board of Adjustment, get very involved in legislative items. But when you do, there's a couple of different rules. First, you're not a judge. You get to consider any relevant evidence that comes before you. And you're the judge of what that is. And secondly, unlike a quasi-judicial, where you have to find substantial evidence to support your decision, in a legislative case, it's just a rational basis. Would a reasonable person come to this conclusion? Reasonable people disagree every day. It doesn't matter that you disagree, it's just would a reasonable person come to this conclusion. Now, every so often you act in a regulatory role. And here, usually a regulatory role is where you're reviewing, like on signs, you're reviewing a staff decision. You can actually appeal staff decisions on the sign code to the Board of Adjustment. Now, with regulatory role, excuse me, there's a couple of things about that. First, the decision of the staff, because they're considered to be the expert, you are to if all things are equal, you're required to give deference to the zoning administrator or the staff decision. That doesn't mean you can't overrule it, it just means you start out from a position of giving deference to it. Now, the standard for overturning it is basically what we call clearly erroneous, which is a very fancy legal term. It's much easier to sort of break that down and say, okay, clearly erroneous can be arbitrary. Arbitrary means unthinking. It means you simply just decided it without any concern for the evidence or anything else. Capricious is that you didn't follow any of the rules. We just don't like the zoning administrator, and we're just going to overturn a decision because we don't like her. Or unreasonable. Unreasonable, what courts define that as No reasonable person could come to that conclusion. And if you find any of those, you can overturn the zoning administrator's decision.
So,
Yes.
you said or as you were describing those, the slide said arbitrary, capricious, and unreasonable. Is it or any of the
You don't have to find all three. If you found one of the three, that would be sufficient. But that's based on the fact that you start out from paying due deference to the decision at the beginning. Now, we have another very, very quick thing to cover, which is a little bit about Robert's Rules. And again, we're not going to spend a huge amount of time on Robert's Rules, because if you've ever actually seen the book on Robert's Rules, the book is about 1,400 pages long. It's like this in 6-point type. If you ever want to be put to sleep, come see me, and we can spend a couple hours talking about Robert's Rules. They were written in 1878 for large meetings. They were never meant for small meetings, but they have kind of become used. Interestingly enough, some of the biggest large meetings that we hold in the United States, such as political conventions, have dumped Robert's Rules. In large part because they are complex and in many respects somewhat unworkable. Now, they're the general guide for conduct of meetings if the City Council's legislative rules haven't addressed the matter. Now, the city has a general format for all meetings. All meetings have to have a quorum. That means 4 members present, alternates can be the 4th. The call to order is the start of the meeting. Boards do not have to have the clerk call the roll. You can just have the clerk note the roll. Most boards have the clerk call the roll because it's traditional, but there's no requirement for that. Many boards would do an opening statement. Welcome, tonight is the business meeting of the Board of Adjustment. We hear variances from the zoning code, interpretations from the zoning administrator, and variances from the sign code. Please feel free, if you want to make a public comment, to sign in. There's a sign-in sheet in the back. Other boards don't. That's really a preference of the board chair. If you want, staff works with boards to even come up with a standard opening statement that a board can use. Then after the start of business, there'll be the call for public comment. The city uses a roster in the back of the room. Public comment can be on any item that doesn't have a public hearing or an item not on the agenda. But if it's not on the agenda, you can't discuss it because you're subject to the Colorado Open Meetings Act, which states that you can only discuss things on your agenda. Now, the City Council does what we call first and second readings. No other board in the city does that, so there can be a consent agenda, which are routine matters that the board can vote on as a group. And then finally, there's reports from the board, and you adjourn. Interestingly enough, people always think, well, we have to have a motion and a second and a vote to adjourn. You don't. You can just move to adjourn, and the chair can determine the meeting to be adjourned. Now, with public hearings, as I mentioned, this is covered in the rules of quasi-judicial procedure. The staff always makes a presentation. The chair opens the public hearing. Applicant presents first, then public comment. Applicant rebuttal, and the public hearing is closed. There generally can be, if there's a question of an applicant or the staff, those can be done first, but once the commission is prepared to discuss, there needs to be a motion and a second. Now, motions are important because once a motion is made and it's seconded, the motion belongs to the body. You can't make a motion and second it and then withdraw it. Once it's made and seconded, it's the body's motion. Until it's seconded, the movement could make a motion and say, oops, I think I made the wrong motion. I want to withdraw it. Once it's seconded, that cannot be done. Same thing, if there's no second, the motion dies. Now, the vote is generally taken with ayes and nays. The city uses electronic voting. This is where lots of times boards get wrapped up. Only one motion or question can be considered at a time. You can't have multiple motions on the floor. if you have a motion and a second, there can be one amendment, you have to resolve that amendment before you can entertain a second amendment. I once had a meeting of a city council where there was an attempt to do 3 amendments on the floor. And it's like, no, we can't do that. We can do one, you resolve it, we do the next one, you resolve it, but only one at a time. Motions can be amended by the member who made it before the second. Once it's seconded, the motion again belongs to the body. And we're not going to go into friendly and unfriendly amendments. That really isn't applicable to what this board does. Subsidiary motions are the last thing we're going to talk about very quickly. When a subsidiary motion is made, such as postponing to a date certain, postponing indefinitely, a point of order, these motions have to be resolved. They overrule what's on the floor. If there's a motion to grant a variance in case number blank, 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 and another member makes a motion to postpone the case for 2 weeks, that overrules the initial motion, and you have to resolve that motion to postpone. Those are basically motions that have precedence over everything else. Occasionally, tabling basically allows the motion to be postponed, and it's usually tabled to a particular date. Once in a great while, city councils or boards will adopt a motion to postpone indefinitely. That essentially kills the motion. That's because once it's postponed indefinitely, there's no way to bring it back. So these precedential motions have to be voted on first. And finally, motions to reconsider. Every so often, boards will say, oops, I think maybe this wasn't the best of our decisions. These can only be done at the meeting where the initial motion was considered or at the next meeting. You can't go back and reconsider things for months on end. Meeting where it was considered or the next meeting. It can be only made by a member who voted in the majority. If you voted in the minority, you can't move to reconsider. It has to be a member who was in the majority. Anybody can second it. And when it's on an agenda, you always will see it as a 2-part item. A is discussion of possible action on the motion to reconsider Board of Adjustment action in case number blank. If that fails, you never get to the second part. It's only if that passes do you get to part B, which is the actual action that you're reconsidering. And so that gets kind of confusing because people are thinking, well, we're going to reconsider. Well, no, the motion to reconsider just puts it back on the floor. You have to pass that before you get to reconsider.
So we're probably unlikely to ever encounter this, but just thinking about how does that actually play out if we approve a variance and then a month goes by until we meet again. The applicant may have already built the taller fence or put up the sign.
And that does create issues because that creates a situation where the applicant may well have vested rights, although with variances there's an argument to be made that until the action is final, I would tell you that I'm advising you or Lena's advising you, we're going to say if you have any doubts, just continue the item. Motions to reconsider are very messy. I've only had to do one here for this city council, and frankly, usually I do about one every 5 years. So they're a very messy way of doing things. And with that covers my presentation, and I'm very pleased to be here. We generally will always have a lawyer at your meetings. It will either be myself or Lena McClellan, who is a deputy city attorney in the city attorney's office. And I'm happy to answer any questions. Yes?
Can you email us a copy of the information you just presented us?
Yes, we will be happy to email both presentations. And you can certainly, if you have questions, contact me and I'd be happy to answer those.
I just think it'd be useful if I could review all that as a set of notes and having the proper protocol for things.
and as soon as the city's, the books are back from the printer, we will have a little handbook with the city's rules of qualification procedure for each of you. And again, yes?
Can you speak to the issue of who has standing to bring something before the Board of Adjustment?
That would depend on the provision of the code. For example, site plans. The city code is very clear on site plans that site plans are a regulatory proceeding, they're not a quasi-judicial.
Right.
And the only party who has a right to appeal a staff decision on the site plan is the applicant.
Right.
And so in that case, only the applicant can bring an appeal. And we recently had a case that involved an appeal where a citizen argued that they should have a right to bring an appeal. And the Colorado Court of Appeals said, no, the city's code says applicant. That's the only party who has a right to bring an appeal. Now, there will be sometimes other codes where it will say a person may bring an appeal. Now, if it says a person, that means pretty much anybody. But most of the regulatory things in our code, such as site plans, will be limited to an applicant being able to appeal.
I appreciate what you just said, and I think you know why.
Yes. And with that, yes.
For signs, since that's kind of new to this Board of Adjustment.
Yes.
What necessarily would normally fall under the Board of Adjustment's purview for signs? Would it be size and location, or would it be an appeal of planning staff?
It could be, usually it will be an appeal of planning staff, and it might be an appeal where planning has rejected the sign because they thought it might be successive, or they thought that the location was improper, and it would be a regulatory decision of planning staff that the applicant would be appealing to you. And the good news is we don't have a lot of sign code appeals, but you probably in your time on the board will have one or two.
We had one a little while back regarding lighting, backlighting.
Lighting, okay.
Outside.
Didn't we, and backlighting and the size of the fly shop line?
Yeah.
Oh, right, yeah.
Went off the sound.
Yeah.
Has the sign code been updated to reflect content neutrality?
Yes, it has.
Okay, good.
It has been, and in fact, we recently just completed another update where we moved it into the zoning code. So it's now part of the land use code, and which is generally signs are done through the land use process, so it makes sense to have it there.
And I think more often than not, you see sign variance requests,
Yes.
not appeals of a staff decision that's coming before you. It's usually because there is an opportunity to request a variance through the sign code. So that the angler was through that way, and I think the backlighting one was. So.
Is it just in regard to size and location, or can it be the number of signs allowed?
It could be conceivably either one of those, but again, just like with any other variance, you're going to have to show a hardship in how the code provisions work a hardship on the applicant. So it's usually going to be more likely, numbers are fairly common, locations fairly common. Occasionally you'll get into, I remember there's a company, Hollywood Video, in the last city I worked in, that actually wanted to do a sign code variance because they were insistent in having their bright blue and yellow sign. And the response was, that's really not a hardship. I get it, you like blue and yellow, but that's not a hardship.
So the number of signs isn't considered a use in the city of Littleton?
The number is considered. We have limits on how much square footage you can have on signs. But occasionally property owners will argue that they have some kind of unique condition that works a hardship.
Right, but in terms of the number of signs they're allowed, since this board can't approve anything that would change the use of the property.
Yes.
So the number of signs, that normally wouldn't come up.
Well, I suppose you could have a variance in theory with the number of signs. For some reason, it works a real hardship. Maybe that property is surrounded by freeways on two sides or something. But it'd be an unusual situation.
Okay.
Again, Mr. Chair, it's a pleasure to be here tonight, and I will get the presentations, we will get those out to all of you, and certainly if any member has any questions, what I'll do is, I'll answer the questions, but copy all of you.
Yeah, we'll make sure to email that out and include Steve's contact for you.
Thank you so much.
I have a question.
Sure.
It's not for you.
Oh, okay.
There are three of us here that are brand new. You, Mike, Tom, and me. We have no idea, other than the brief comments that you made. You don't know us from Adam. I'm not saying we have to do it tonight, but I think it's appropriate for the rest of this board to understand what the background is and what people bring to the table, why we got appointed by the city council. We don't have to do it tonight, but I think maybe at the next meeting, we ought to schedule some time to do that.
I agree, maybe we should have a party.
I'd rather have the discussion and then the party after.
Birthday party tomorrow, how about that?
We can certainly, I'm sure that the clerk has a bio from you, and we can certainly provide that to the boards, and boards do this different ways. I mean, some boards will do that.
And now that you have a chair, right, it was a unique situation
No, I
that the
understand
chair, you know what I mean, was termed out, so now that we have a chair, well,
No, I understand.
also, the other protocols, we will reach out to the chair to make sure, however, some of these pieces he wants to manage,
But I think that it
are
would be
managed.
really
So I'm
prudent.
saying to you, Ken, typically what we do is we work that through the chair and then provide that to new members. So that's a conversation we can also have as well, so.
But we definitely,
But we can get out the info that we have.
and the clerk will have some bios and things, so we can do
Yeah.
that.
Great to meet everyone.
Is there a motion to, is I hear a motion to adjourn? Mr. Chair, we adjourn?
Fourth night meeting, I
Good to meet you
Nice to meet you.
Thanks for your time.
One ahead of time, where we just voted to approve the previous.
out there.